Here with Jeff Justice Seminars for Court Reporters. I want to thank you so much for deciding to choose us to get your online CEUs with. We promise not to disappoint you. We provide laugh-packed, content-rich seminars so that you can get your CEUs from the comfort of your own home or office. So basically, you're going to watch the videos. As you do, print out the PDFs for the quizzes, answer the questions as you go along. At the end of the whole seminar, so if you're taking a 10-hour seminar after you finish all the sections, email me all of your answers. I will grade them and get you back your letter of completion for your state, and if you're an RPR, the proper forms for NCRA. So get ready to laugh and learn with Jeff Justice Seminars for Court Reporters. Program, and it went over great, so we've kept her with us. Doing programs on grammar, punctuation. As with all of our programs, the one thing I can't stand is at the end of a program, somebody come up to me and say, well, that speaker that you had up there, they said this, and that was wrong. Well, why didn't you raise your hand during the program, right? Yeah. So if you disagree with any of us for anything, please let us know and let's talk about it, because maybe you are right and we're wrong, or maybe you've been doing it wrong forever and now you're find the right way to do it, okay? So please raise your hand. What makes these programs great is the participation, and that was, I loved when I came in at the end of Anita's program before, people were raising their hands, they're getting involved. I mean, this program's for you to make you better reporters. So we can only do that by all of you helping each other and participating. So without any further ado, a nice round of applause for Carrie McHugh Transcription Hill.
Okay, good morning, or good afternoon rather, ladies and gentlemen. It's nice to see a couple familiar faces, and it's great to be back here once again. I myself am an Illinois court reporter, like Jeff said, so I know the importance of maintaining our CEUs, especially after we've worked so hard to get our license. The Jeff Justice Seminars are a fantastic way to get the CEUs. Since 1999, I've only attended one other seminar other than the Jeff Justice Seminar, so I'm proud to be presenting. And now, as he mentioned, they're also available online, so you can take them from the comfort of your own home and your PJs, well, you know, so that's nice. You just heard Anita Paul speak, pretty big shoes to fill, so I'll try my best. But she's a dynamo court reporter and speaker, I'm sure, a wealth of knowledge. So the name of my program is Transcription Tells, and I'm sure, and the reason is because I'm sure as reporters we all have a tell or two to tell about a difficult transcript, a humorous transcript, an emotional transcript, and perhaps in a little bit, if time allows, we'll share some of our stories about different proceedings that we've been in. And also, like when you're in a deposition or in court, things can sometimes go absolutely wacky. I've had attorneys threaten to throw each other out of the rooms, or they might be having a bad day, so they decide to take it out on the court reporter. And what do? We sit there and maintain the integrity of the record and be cheery no matter what's going on in our life. We still have to maintain the integrity of the record. So during this program, if you need a bathroom break, feel free, just go. Please come back so I know I didn't scare you away. And if somebody has a question, please raise your hand and ask the question. If I don't know the answer to it, I'm sure with all our collective knowledge, somebody can figure it out. And we also have our smartphones, so we can look it up also. Okay. So when you're doing these transcription tells, when we're doing a transcript, it's second nature because most of us has been reporting for years. So we pop in that approved file and there we go, we're editing away. But sometimes something might come up and give you pause and make you ponder, well, I haven't done a certified question in a long time, how do I do that? Or maybe you're training a new reporter in your office. So we'll go over some of the things that are involved in the transcript. And that's basically it. So the most important thing I would like you to learn today, have fun. Please participate. It makes it better for all of us. And by improving your transcription production, it cuts down time on your editing and it saves time and you make more money. And remember, the spoken word vanishes, but the written word remains. So we'll go right into section 1, all about the transcript, and take 15 minutes. This isn't not a race, so take your time, do it. And for you overachievers, which I know most of us are, don't go ahead to the next section. Stop at the first section, take 15 minutes, and we'll go over our answers, okay? Okay, are we all ready? Okay. So the first question is list the 4 essential pages. Let me start all over. List the 4 essential inclusion pages that need to be included in the deposition transcript, and then list the one that is optional depending on what the witness wants to do. Who would like to answer that question? Okay, thank you.
I put down the title page, the caption,
Right,
the appearance page,
Right.
the index page,
yes,
the recorder certificate,
right,
and then the signature page if it's reserved.
absolutely. Okay, the title page, the appearance page, index page, our court reporter certificate, and the witness cert. And just a couple of things to talk about. In the caption, you want to write it exactly as it is presented to you by the attorney. If you find out later that the witness's name is spelled differently, you can spell it right. You should spell it right on the index page and the setup and throughout the deposition. But leave it as exactly as it is on the caption.
But what if it's just a typo from the secretary at the attorney's office?
No, I would not if it's a typo. If it's the caption that they give you, because maybe that's how it's filed in court. That was a good question. If it's just a typo from the secretary, it could be
But you don't know that.
You don't know
What
that.
if it says like and Illinois Corporation, it says and Illinois Corporation instead
Well,
of
yeah, then
and.
you,
Okay, the question was if it says and in Illinois Corporation instead of and. I
Might change
believe
it,
that
yeah,
would be
but not
fine
the
to
names.
change.
Not
Yes.
the names, right.
Yes.
As far as, leaving it wrong,
As far as leaving it wrong, yes.
I've gotten captions that I've copied where either a secretary or another reporter, I was copying their caption, and they did it wrong, but on other captions I've seen where it was right. So I do not, if I know that it's wrong, the spelling of a name, I correct it. Because the caption you got could be inadvertently misspelled. That
Okay.
doesn't make it the caption that was filed with the court.
So this would be a scenario when you're following someone on a job and you got a caption from somebody else in your office maybe?
Could be,
And you've seen it, no?
it could be on the job, and the caption came, the secretary typed the name wrong in the
You might-
caption.
They might have 2 different ones and it might be spelled different in both, right?
Yeah, but you
Like
can
at
just
the same depth? Like the,
It was just a misspelling that somebody made, and the lawyers didn't correct it. They didn't realize that it was misspelled, and half the time they don't know anyway. And you look at something else later on and you see
The
you're
correct
correcting something else,
spelling.
and there's
Okay.
the correct
It
spelling.
could be on 2 different documents, one spelled wrong, one spelled right, and Rosemary has something she would like to add.
you could always check online. I know the Circuit Court of Cook County has a docket search,
Okay,
and you could get the name there.
okay, so you could check
And that
on,
is how it's filed
check online.
with court.
Could be.
No. Or another, they're not, she said, are they gonna pay you to go online to take the time to do the
Takes 30
research? But, also, you could ask both attorneys, how is it correctly
Doesn't really
spelled?
make a lot of difference, does it?
It,
Doesn't make a lot of difference in any event.
well, it could make a difference.
We've always been told to just leave it as is, whatever.
We were always
whatever
told
the
leave it
office
as it
says.
is too. Leave it as it is too. Okay, then on the appearance page, when you get the lawyer's cards, make sure to ask, is this still your right address, you know?
Evidently, yeah.
Yeah, and,
Has left their old cards and removed.
right. And also if it's sure?
Does anybody put email addresses on the appearance page?
Yes.
Fantastic question. Does anybody put email addresses?
Yes.
I think we should start, everybody should start doing that, if they're available to us.
Sometimes.
If it's on their cards.
If it's on
Or
their
you
cards,
ask-
put it on
or you
there.
just ask.
That's a fantastic point. And then if it's an et al. Caption, make sure that you put the right attorneys representing the certain people, et al. Thank you. So we want to do that. On your index page, you want to, the attorneys may not want to read through everything in the transcript, so they flip to the index page to find out where they're questioning. So, and it's also important, I think, when you're marking exhibits, if the attorneys do not give you the exhibit, make sure you put on there that you are not in possession of the exhibits, because you don't want them calling you screaming, well, where's Exhibit A if you never had Exhibit A?
Exhibits retained by counsel.
Exhibits retained by counsel, that's a good parenthetical to put on there. Sure.
Or one missing,
Or one missing.
just next to that line.
Next to that one. And then our reporter certificate, it says on there, we did the job to the best of our ability. If they bust out in Chinese or Russian, there's nothing we can do about that. It's to the best of our ability. And then, of course, the WIT cert, depending on whether they reserve or waive. And also, if it's an evidence step, there's not going to be a WIT cert. So, okay. So, shall we move on to number 2, question 2? Would anyone like to read question 2?
D.
I'm hearing answers, but I don't know who's. Okay.
When an attorney is at a deposition and asked to certify a question, he or she is doing what?
D.
D.
That's what
D. Okay, that's correct. The question is, when an attorney is at a deposition and asked to certify a question, he or she is doing what? And the correct answer is D, requesting that it be referred to the court for a ruling for an answer. And I was actually at a deposition once, and the judge was saying, you have to get these cases done, you have to. And one of the attorneys kept saying, well, certify that question, certify that question. And the attorney's like, this is getting ridiculous. The index is going to be a little booklet by the time, so they got the judge on the phone to make him rule it on them.
Yeah.
But I was so nervous, but thank God I had like 10 minutes while they were getting the judge on the phone so I could go through and read my notes and all the colloquy and the objections. But talk about a stressful moment, but that was one of my perfect readbacks throughout my career. Not that I've had too many, but that was a good one. Oh, and then that reminds me, do you remember a couple months ago about the Justin Bieber deposition? And it sounded like, it was all over Facebook, and it sounded like they played audio sync back when they said, can you repeat the question? And I'm like, was she too nervous to answer? So did she just play her audio sync, or? I've never seen that done before. So,
It happened in our office.
it happened in your office, you reporter?
She got a very
I
big
don't know.
Did,
she just played back the audio instead of, maybe she couldn't read it, or she was nervous to read it, but she just pressed the audio button. And the attorney was livid and called our office and said, this is an incompetent girl, shouldn't even know how to read a note. And she was crying. It was a terrible.
what, is your name Marlene?
Yeah.
Marlene just gave an example of a girl in her office that I'm repeating this so everybody can hear, but she couldn't read back, or she was just too nervous or something, so she played the audio sync back, and the attorney was livid. He called the office and complained. So, yeah. We shouldn't. Note to self, read back. Yes, yes. Where I started, yes, ma'am, Rosemary.
I've heard of instances, so, and I'm not accustomed to earbuds, but I've heard of instances where reporters will find the question, because it takes us so long to go back and find the question. She's actually playing it back in her earbuds so that she knows exactly, do you know what I mean? And
Well, that's a cute little cheat,
Yeah.
because before I got and I'm a newcomer relatively newcomer to Case Catalyst, so because I was on X-Scribe for umpteen years, and an attorney actually said, oh, well, you don't have that new computer, well, it just it says it right back, and, you know, and a reporter showed me how that works, and it's like, why would a reporter be doing that? You know, giving away our secrets.
Right. Did you want to say something, Valerie? I thought I saw your hand
That
raised.
happened to me one time. I was at court and I, you know, somebody objected and the guy was lying. So we went into a whole different courtroom, sat down with the judge and the attorneys, and so I'm listening to it in my ear and I'm trying to repeat it as the attorney's talking, and he was talking so fast I could barely keep up, but I made it through it. But that wasn't a good example. I mean, it can work, but that was bad. He's just talking so fast.
High blood pressure moment.
Yeah. So I guess it's okay to listen to the audio sync, to listen for the answer, but just repeat it verbally. Don't just be lazy and put, okay, here you go. But, you know, it's so hard. When I first started reporting, I was at Wolf Rosenberg, well, first Cynthia Varelli for a while, and then they converged to Esquire. So Wolf Rosenberg, Seymour Wolf trained me. And he's like, don't take a tape recorder on jobs because you get too dependent on it. And I agree with him, you do. But, dang, sometimes you just need that tape recorder. Because, you know, if it doesn't write right away and it's a name or it's just, that tape recorder is kind of part and parcel to what we do, I think. Okay, so I believe we're on to question number 3, right?
Right.
Okay, who would like to read number 3?
When a witness doesn't answer verbally but shakes his or her head, which parenthetical should you use? A?
Yes, yes. When a witness doesn't answer verbally but shakes his or her head, which parenthetical should you use? You should use A, no audible response. Because we don't want to be interpreting the answer. And the attorney really should say, is that a yes or a no? Not leave it up to us to decipher. And sometimes if the court reporters do ask for clarification, some attorneys don't like the court reporter interrupting at all. So,
Yeah.
and maybe, I'm just speculating, but maybe the attorney didn't want his client to answer the question.
No, it's gonna happen.
Somebody lost a jacket. Any takers?
I don't think everybody puts no audible response, though.
No,
I think
no.
there's varying.
Nodding.
Indicating.
Indicating that?
Yeah, just indicating that there's a gesture, there's some sort of a, so you know that they did something, but you're not interpreting what it is, it's just indicating.
Okay, they're saying a lot of people now, instead of not audible response, they're just putting indicating, and they are indicating something, and you could do that, but what I usually use indicating for is if pointing, very good, or how far behind the semi were you? About this much. How big was the bruise? This much. That's how I usually use indicating. It's just a matter of preference. I mean, there's no right or wrong way to do it. I think maybe what your firm likes. Okay, number 4. Any takers on this one? A. Please do. No, yes.
When a deposition is continued to an uncertain date, you should put a whereupon the proceedings were continued 90 days.
Yes. And that's just so it's not left hanging out there. You can't put further deponents saith not because there's still, it wasn't finished and you don't know when it's continued. So it's not just left hanging out there. Thank you for that. Any comments on that? Yes, ma'am.
Me?
Yes, Cheryl?
The whereupon the proceedings were continued, I have no problem with, but I do with the sign I die.
Why?
I was told many, many years ago, it's just very old-fashioned.
It is old-fashioned.
It's just not put in anymore.
So what would you put in now?
Whereupon the proceedings were continued, to a date uncertain,
Okay.
generally, continue generally.
Cheryl is saying that now she would just put in whereupon the proceedings were continued to an unknown date,
Generally.
or generally, because signed die is too old-fashioned. Did somebody else have a comment on that? You're saying the exact same thing? And did your agency tell you to do that, or
Yeah, years ago.
years
Many,
ago? Okay. Val, are you still?
I think somebody told us to not use that a while ago, but then they put out a form before I worked, and I think it's in there again.
Right. It depends on the form books that you have, so.
Means without date.
I'm sorry, sir?
Sine die means without date.
Right.
Right.
It's not, they're saying it's not old-fashioned, it's Latin.
Right, the attorneys will use this.
The attorney, what, huh?
I'm just saying, I mean, I've had motions or whatever, and attorneys always quote those, all those different terms still, but it's
Right.
probably up to what your agency wants.
It's up to what your agency wants, that's correct. Okay, number 5. Who would like to read number 5? You're so quiet. I heard you participated so well for Anita. And she's right back there, so I need some participation. Who would, okay, thank you.
In the following example insert where you would put certified question number 1, I would put it right before the question.
Right before,
When your
right.
husband found out about the affair with your boss, that when he filed for the divorce.
Okay, that's correct. She said that she would put the certified question right above the question because that indicates, boom, it's a red flag, it's controversies coming up. Right, very good. Okay, number 6. In the example above, how would you indicate the certified question on the index page? Page line number? Uh-huh. And would you put it in between?
A heading, certified questions, number
Right.
1, page, line.
Okay, so a heading, and I would put it in between the witnesses, well, opening, closing, and then you list your witnesses. Then I would put the certified question header in there, then question number, line number before you go on to the exhibits. That's right.
Oh, you do it before the
I do it before the exhibits because
Our form book years and years ago said after the exhibit.
after the exhibits,
I don't think it matters.
I guess it doesn't matter. It's just I'm kind of thinking it's following, huh? A stylistic, right. And we'll talk about that later. There's so many different stylistic guides out there now. Greg's, Morrison's, Margie Wakeman. It's like, who do you listen to, Grammar Girl. Some of these I'm like, I'm going to listen to Grammar Girl? So she's got some good tips, but has she been reporting?
How about, now here's a question, I know it depends on the firm, but some people capitalize the whole question. Put the little asterisks and everything, and capitalize the certified question.
Julie
On the
says,
actual transcript.
on the actual transcript. I'm sorry, what's your name?
Jody.
Jody?
Yeah.
Okay.
It's
Yeah, you're on
Anita's
this side.
handwriting.
No, you're on this side of the table.
Oh, yeah,
Okay,
you are.
she said, some agencies will have you capitalize the whole question, or with the asterisks. Do you do that? No. The certified question. Mm-hmm. That's probably just a stylistic
Yeah.
thing too. I mean, it would look nice, it would grab your attention, but I don't.
Yes. Oh, yeah.
Okay.
Looks nice.
Anything to add back there, ladies? Okay.
Julie says it looks nice.
Julie says it looks nice.
Julie says.
Okay, question number 7. If exhibit number 1 and 2 are marked for identification, but the following exhibit isn't marked, how do you indicate that on the index page? You wouldn't do anything?
Exhibit 3 not marked.
Exhibit 3 not marked? And you wouldn't put anything till you had everything figured out?
At the end of every dep, I'm like a exhibit Nazi. You're just making sure you have everything, and you gotta let them know, hey, I don't have this exhibit.
Okay, so she waits until the end, she's an exhibit Nazi, and then she we'll mark it on there somehow. And I was gonna say also, I think you have to follow the attorney's Q and that CUE on this. And that word will come up later in the handout. But if there's like so much emphasis on that exhibit, I would list it on the index page as referred to,
Yeah,
but not marked, a reference, right.
right, because they would
But-
still want to know about it.
But if they just mention it once and it's never brought up again,
But are you marking it or not marking it? I don't understand the question.
I don't see how it becomes exhibit 3, it's not marked.
Right, if it's not exhibit
it's not exhibit 3, okay. You're right about that because it was never marked. It was never
so
marked.
then it shouldn't be in the index. Why
Right.
Sometimes they'll say, I'm gonna show you this, but I'm not gonna mark
Mark
it.
it as exhibit. And I think that's self-explanatory. If they say I'm gonna hand you this, but I'm not marking it as an exhibit, that's self-explanatory. That wouldn't have to go on
But
the
there's, my
index
point
page.
is, there's nothing you have to do about it.
There's nothing you have to do about that period.
No, but
In the story, you're right.
But I was inferring that, like, you skipped number 3 and you had 1 through 10. That's what I thought this meant.
Okay.
So wouldn't you indicate
Then
exhibit
you would
3 wasn't
indi-
marked? Because then they're going to be like, hey, I didn't get number 3.
No,
Yes,
it
I-
was marked, it just might have not have been referred
That's
to
not
or
what this
withdrawn.
says. It says it isn't marked here.
But it's not saying exhibit 3.
Well, I'm just, never right. A lot of
If it-
interpretation.
Right, they didn't mark it, so it wasn't an exhibit. Huh?
It says the following.
Exhibit number
Number 3.
Is it marked? How are you going to take this? Okay, well, I'm just, it skipped a number. Okay, I have it right here. It's,
They never marked a 4 or 5.
They thought
But
they
at
did.
the end of it, I asked them to state on the record that there was no exhibit 4 and 5.
Oh, that's
Marked
good.
1, 2, 3, 6, 7, 8.
that is a really proper way to handle it. At the end of the deposition, she asked the attorneys to state on the record that exhibit 4, 5, and 6 were not marked. So that clarifies it. That's a very good point.
There is no exhibit.
There was no exhibit, right. Very good point. Yes, you have a question?
I had that's the last couple of times where they said, I'll mark this exhibit A, and they never mark it till the very end. So what do? Do you put a parenthetical there, or do you put it all at the end?
Okay, her question
It
is,
never gives me time to mark it.
okay, they say I'm going to mark this as exhibit 1, and they never mark it until the end of the deposition.
They never even.
Or they never even give you time to mark
They
it.
never give me time to mark it, but they give it to me to include in the deposition transcript. So then I mark it later, because I know these guys.
So-
I mean, what would be the correct way to do it?
I put the
Does-
parenthetical in when it's first mentioned.
You would put the parenthetical in when it's first mentioned?
Mark this as number 1, and then, is the attorney gonna call you back and say, I didn't get those?
They're not going to care.
Right, go ahead.
So they're just in a rush.
They're in a rush.
So they do this to all of the exhibits, and they'll put their own marking. And I've had attorneys, they don't even care about my sticker, they're writing
I've
on
had
it
that
themselves,
happen.
and they just keep going, so.
The attorneys more and more nowadays are marking their own exhibits. You love it? Yes.
But what about a case where they're all the exhibits are pre-marked in the beginning, but now as they go through the depth, they're talking about them, then do people usually put like they were referenced on these pages? When
Yes, when
they,
they're first
because a lot of
mentioned.
times they want to know, where did I talk about exhibit 1 or 2?
When they're-
At least
when
where
they're-
it starts.
That's in the word index anyway.
It is, it's in the word index.
It's in the word index. Yeah, it's in the word index. But if they mark them all at the very beginning, I put whereupon exhibit 1 through 10 were pre-marked.
Right.
Or certain documents were marked.
No, I index when they're first talked about.
Right.
You index when they're first talked.
First talked about.
That's what they're gonna be looking for, don't you think? In a hurry?
So when they look at their index, they can see page 42, page 66, page 73. So I
So-
referred to as a column, not marked.
Referred to as a column on the index page.
On the index, and then I mark them as they.
You mark them?
Something marked.
Okay, I think the consensus on this side of the room, if I can remember it all, on the index page, you mark them as they first introduce the document, and then and then a referred to column. And I think that is a pretty good way to do
I've never
it.
referred to column.
Huh?
I've never heard of a referred to column.
You've never heard of a referred to column?
Oh, can I say something about that?
You may say something about
Sometimes
that.
if you're in a case where there's multiple deps, multiple days, they'll sometimes say, I'm taking Mr. Smith's deposition. Sometimes they'll say, I'm going to refer you to Exhibit 2 for Mrs. Jones' exhibit from yesterday.
Very good
Previously
example.
marked.
That's when you use,
Previously
I'm not
marked.
marking it though. He's referring to it.
But the exhibit was marked from
Right,
yesterday,
right.
previously marked.
But what I'm saying is,
He's just showing it to her. He's not marking it again. It was previously marked, so you
he's
would have
referring
put.
to an exhibit.
Like,
Right.
I just had that the other day. I marked like 10 exhibits, but there were like 15 exhibits that had been marked in other depositions.
Right.
All not in order, all, and after the exhibits, the index of the exhibits, then I put previously marked exhibits. And then I list exhibit 2, exhibit 10, because I'm not marking them. They've been already marked in previous depositions.
You're just using a different wording than
Right.
reference. That's all
Right.
that is.
But I don't have a column for. it's a-
Right,
it's a
I
separate-
understand.
More
Okay.
of a stylistic.
Right, it's more of a stylistic thing if you want to list it every time. But, yes, ma'am.
Say even in the concordance index that they can look it up where it's been referred to. I'm not their personal secretary. I'm just telling them where it's been marked.
Okay, I like that. She's not the personal secretary, it's in the concordance index and they can find it there. Okay.
And
And-
I was gonna say, we have a client who pre-marks everything. And so, okay, referring your doctor to Exhibit 91, page 173, and they have their own system. That's not something I'm keeping track of.
Right, okay.
Only if, okay, I'm marking your CV, and I don't get those documents unless the other attorneys are saying I'd like the exhibits referred to, those specific pages attached to the transcript. But
Okay.
I don't have that in my index.
No, that would,
Exhibit 91, page
no,
176.
absolutely not, no.
Only the CV that was then marked
Right,
as whatever.
very good, yes.
Because actually, they could show a witness any document that's not even an exhibit. And that means we would have to put it in the index that referred to Google map of Chicago when it's not even an exhibit.
Right.
So,
No, every time they show, if I'm understanding what you're saying, every time they show a witness a document that is not marked as an exhibit, no, you would not put that on there every time. No way. Only the ones that they've asked you to mark or to attach.
If they get a key index page, they're going to see it.
They will see all of that on the key index. Correct. Any comments on this side of the room? Okay. Have we had enough exhibit talk for a minute? Okay, number 8. And I have a feeling, well, let's see. Okay, number 8, if the deposition is adjourned and the parties are not in agreement, would this be a proper parenthetical to put in? Whereupon at 2:30 p.m., April 10, 2014, the deposition adjourned pursuant to the position stated herein by the respective parties. I put yes. Yeah. So you know that
Mr. Smith got up and walked out.
now, the last seminar I taught, they absolutely did not like that ideal. They're like, the record will speak for itself, you can see what the attorneys say, but just to find, why are you shaking your head?
No, we both of us don't like that.
You don't like it.
We don't like it.
They're not really agreeing.
They're not in agreement.
It's by one party, not the respective parties.
It's kind of like a nice way to say
disagree.
The two attorneys are arguing. Right.
That's what it sounds like.
That's exactly. The court reporter is politely saying that the two attorneys are arguing.
Who wants to get into that?
Right. Right. Okay. Now, number 9. I would like someone to read number 9, please.
And in the hearing, if they are taking a voice vote rather than polling each individually, would it be appropriate to use as parenthetical? I put yes.
Yes, yes. Some people don't like the A's or whatever, but I do a lot of pension board meetings, and so when you are polling, yeah, a voice,
Or
a
when they
roll
swear
call
in a
vote,
jury?
yeah, when they swear in a jury. Because if they all say yes at the same time, it's too hard to keep track of what order set it in.
All don't say yes, there are some A's and Nays. What does chorus mean?
Right, well, that doesn't usually, okay, well, let me give you an example. If they're asking, are you going to award this disability? They'll take a roll call vote, yes, no, the dissenters will have a chance to speak. But if you're in agreement to adjourn, you're not going to have, usually you're not going to have an A, it's going to be an A.
Sometimes.
You could, and then in that case, you would have to speak up as a reporter and say who said nay.
Well, the chair.
Or the chair
All
would
in
have.
favor, aye, all opposed, nay. And then he makes the call as to whether it's
Right.
consensus or not. But I'm just wondering, Sam answered as to what chorus meant.
Okay. In unison.
Generally, this is for a meeting. not-
Yes, that's in a meeting.
Or a convention.
Yes, correct. And that generally is in a meeting or a convention. Okay,
Well,
yes, ma'am.
I mean, that wouldn't the same apply like when you're voir diring a jury? And
Voir
you
diring
get,
jury.
4 people or however, could be all 12 saying yes to one of those ridiculous general questions that you want to slap the attorney for even asking.
Mhm.
So, I mean, that's, what do you put? I mean, if you, and you may not, they're not all going to say yes. Some just don't say anything, or they might say, but you have to do something that,
So Sam, what would you do in that case? Pulling a jury in, and some may not answer, some
but
or
they all really mean yes.
they all really
you know,
mean yes.
Because it's,
I didn't hear the question, and I haven't been in a jury trial for 40 years.
I'm not asking you a question, Sam.
Okay, I would put in the transcript, like veneer man or the, and I would say yes. Because you've got all of that group saying yes.
Number one.
But that's what I would
Or
put,
panel
not
number
necessarily a
You put a
parenthetical.
parenthetical in,
But
okay.
the veneerman, yes.
Veneerman, yes. Okay, that's good. That's an easy way to settle that.
Didn't say anything, it's not my guess to figure out which four didn't speak.
And then it's up to the attorney to figure out which four didn't speak.
Who cares?
It's a terrible job,
Yeah. And I think Rosemary said, don't send me there. Oh.
Give me the doctor.
Give me the doctor, I know.
Doctor.
Yeah. Well, I had my share of court time. When I first started, the agency loved to send the new girls. You'd always have court every single day, either in the morning or the afternoon, and then at death. Couldn't get away from it. And there were times when you would not have somebody to replace you. You're supposed to call at lunchtime to get a replacement. Sorry, we don't have anybody to call. I was there one night until 7:00 p.m. Ran out of paper, flipped over, and started writing on the back side of the paper. Those were not fun days. Then you're icing your wrists on the train ride home. And, okay. Let's have somebody read number 10. Valerie?
When the last name is pronounced differently, as in the example below, how would you indicate that in the transcript? I said B.
Only after the answer. That's correct.
And I put different pronunciation.
Different pronunciation.
Why would you?
Why would you? Well, because somebody could say Mr. Tomato, oh, it's Mr. Tomato, just to show that they said it different. And I wouldn't do it every single time because you're padding the transcript.
Isn't that giving your input?
That's not giving my input because I heard it said two different ways. I heard it said yes.
I I might actually put it in there as phonetic and actually do it phonetically.
How could you do that? How could you show
So that you have some kind of an
name,
idea of what's
Isn't that the
going on,
same
not just that
thing?
it's different, but that
Just an A along
It
with
She would put it phonetic and spell it like that, and you're saying that's the same kind of thing?
I'm saying
You're saying that it doesn't need to be there?
it doesn't need to be there. You don't need any kind of differentiation. Unless the attorney, is saying, oh,
Well,
I'm
then
sorry, I
that's-
mispronounced
yeah,
your name or something.
that's
But that's
not-
not what's
Okay,
here.
well, that's what I'm
It doesn't make or break
implying.
the case either.
It doesn't make or break the case either, you're right about that. If the attorney says, well, I'm sorry, then you put different pronunciation. Sorry, Miss, and he did say there, sorry, Mr. Tomato, or whatever, tomato.
potato. Let's call the whole thing off.
Okay.
Really?
I had to do it.
Okay, while in a deposition, attorney tells you to go off the record. You should immediately go off the record or keep writing until both parties agree to go off the record. B, right? So B, you keep writing until both parties are in agreement because you don't want them to accuse you of being biased or this one hired you, so.
Sometimes she needs to say to the other guy, because he may not have said anything in agreement or disagreement, say, is this off the record?
Is this off the
They look
record?
at you like,
Yeah,
yeah.
I speak
of
up,
course.
yeah.
If you're a freelancer, you may have the problem of your guy saying, I told you to go off the record.
Yeah.
Yes, if you're a freelancer, you may,
You gotta keep writing though.
Yeah, just in case.
just in case what?
Well, just in case
There has to be agreement.
there is no
There has to be an
and-
agreement.
And the attorney
Yeah.
wants the other attorney's comments on the record. Maybe he wants to show a judge at some point that he didn't agree to go off for this particular
Right, you
discussion.
keep writing because he may want to show a judge at a later time that he was not in agreement and he wants to have what he was saying still be preserved on the record.
Right.
I have also seen where the judge has said go off the record, and the attorney has said keep writing. What do you do then?
What the judge says.
What the judge says.
And I've had a case with that, like, exactly like that. That was my all-day job where I'm writing on the back of my paper. It was lovely Judge Sheila, who is the nicest judge in the world. And there were two attorneys, and the judge kept saying, go off the record. The other attorney was getting really hateful with the judge. And I went off the record, and it wasn't the attorney that hired me. And he's like, oh, you just went off because I didn't hire you. I said, no, I went off because the judge told me to go off. And he's like, and then he got mad at me, and he's like, well, he's nobody. He's just a man in a black effing robe. But, yeah.
Judge Strawman Jan.
Yes,
Kind of on the same subject.
kind of on the same subject here.
So you know when you go to an arbitration and you're hired by one side and they say, I just want you to take the plaintiff?
That happens.
Oh, that's tricky territory there. If you're at arbitration and they say, we just hired you to take the one side.
So a client of ours threw a fit because the other guy wanted us to take it and the reporter did. Actually, there's a rule that's specific to arbitrations where if your guy hires you just for the plaintiff, you don't have to take anything else.
That's true.
So,
Really?
So, yeah.
Would you mind, I need to repeat everything, and I don't think I can repeat that. Can you come up here and say that for me, please, so everybody can hear you?
You look great.
It's my friend Valerie, she's assisting me for the moment. Okay.
So, at an arbitration, if you're hired by the defendant and they tell you just to take the plaintiff's portion of the testimony, at my office, the other side wanted us to take, the defendant's portion also. And the reporter did because she didn't know any better. Our client threw a fit, called the office, ranting and raving. And it turns out that if you are hired just to take that one portion, there's a rule where you don't have to take anything else.
They can hire you on the spot.
Right. The other side can hire.
You and then I don't know what you do.
And then you have to call into the office, and say, do I have permission to do it?
And then you have 2 attendances.
Right.
I didn't think about that, then you have 2 attendances, yeah.
Get a deposit from the other side.
We have a comment about that
Yeah,
here.
the same thing happened to me about a month ago. Same exact thing, and I went to my attorney and I told him what's going on. I said, you're gonna have to take care of this. I go, because I'm gonna sit here and I'm not saying nothing. I'm not doing nothing. I'm not bound. I'm here for you. you're the one that called our office. I said, so you need to talk to this attorney, and I let them do it. Let them fight it out. And if the attorney isn't gonna say, if he wasn't gonna say anything on my behalf, I still wouldn't have done the other side, because the agency hired me to go do this specific thing. And when I went back to the agency and the owner came out and told me about it, because the other attorney, they were actually both clients of the same agency. I immediately went back and told the owner of the agency, and he said, you did right. I said, I told him, I said, you hired me to go do this, to do the plaintiff's testimony, and that's what I'm hired for, and that's all I'm doing. And he goes, you did right. And he did get a call from the other side, and that's his problem.
Okay, so he,
Because it is a rule.
It is a rule.
It is real, and it's very common, because they'll use it almost like, instead of taking a real deposition, they use this like a deposition in an arbitration.
okay. So that happens in an
It's happening
arbitration.
more and more with
It's-
reporters where I'm from. Yeah, it's happening more and more.
The other side?
Just stick to your guns. I mean, we're not doing anything wrong.
So basically, to boil it down, because we've had a lot of conversation over here on the same topic, when the attorneys are saying that you should continue writing, just do what you're hired to do, and your agency will usually back you. Because if you're in arbitration and they're basically trying to make a deposition out of it, maybe, so just do what your job is to be done.
And actually, before I asked my attorney to take care of it, I asked the arbitration panel. I was kind of disgusted with them. I turned to them and I said, you know, there was a big ruckus, and I thought I could look into the arbitration panel like as a judge and say, can you direct me on this? And they looked at me like this.
Right.
And I just like, oh, if that's the way you feel, fine. And that's when I looked at my attorney and I said, you need to take care of this. I said, I'm not writing it, I'm here for you, but this guy's coming at my face. This guy.
Did you sit there throughout the whole proceeding?
Well, the other attorney called our corporate office, and he had his iPhone there, and he was like shoving up my face, and he started touching me, and he goes, you want to tell your office that you're not taking it? And I just looked at him, I said, don't touch me. I just looked at him, I said, don't touch me. And he goes, it was ridiculous. He goes, here, she wants to talk to you. I go, I'm not talking to anybody. He goes, here, take my phone. I go, I don't want to hold your phone.
I hope for the people that are going to be watching this, while he was at the arbitration, the other attorney actually called the office and was shoving the phone in his face, getting pretty belligerent.
And he was like demanding that I take my body and hold his phone. I said, I don't have to do anything with my hands.
No.
He goes, you hold my phone right now. I go, I don't have to hold anything.
Okay, wow. I haven't done an arbitration in years, but if they said just the plaintiff's testimony or whatever, I'd hightail it out of there so quick. I'd pack up and leave before.
We leave after the plaintiff is done testifying, we leave.
Yes. Okay, ma'am.
I've actually had the opposite experience with the arbitration panel.
You've had the opposite experience with that?
Hired to take down just the plaintiff's testimony. I stopped writing, and they called the next witness, and the arbitrator said, what are you doing? Why aren't you taking this down? And I say, I was hired just to take down the plaintiff's testimony. No, that's not going to fly here. You have to take everything down.
I would keep writing.
Okay, this lady in the back had a situation where she was at arbitration. It was kind of the flip side. She stopped writing after the plaintiff and the arbitrator's like, why are you writing? Why are you not taking this down? And so what did you do?
I ended up they didn't give me the opportunity to call the office to find out. The other side isn't saying we're going to pay for half your attendance or whatever the issue is going to be. So I just figured I'm there, I'll take it down, whatever happens, you know.
So she took it down because she was there wasn't time to call the office. And who ended up paying you? Did the firm split the bill or did you get paid for it?
Oh, I have no idea who. You know, there's a minimum attendance.
Okay, the minimum attendance. They probably didn't even write it, right?
So however the office handles the billing, I have no idea, but years ago that happened though in judges' chambers where the attorneys wanted to go off, one of the attorneys wanted to go off the record, the other didn't, the client that hired us. So I kept writing. The judge is like, off the record, this reporter, and the client's looking at me like, don't you dare go off the record. The judge says to me, if you don't go off the record, you're going to be held in contempt of court. Calls the bailiff, the sheriff in to hold my hands behind my back on the chair. What? I always listen to the show.
Yes. So the same lady that had the scenario about the arbitration, she was in court in chambers, and her attorney that hired her said, "You better stay on the record," and the attorney said, "Go off the record," and the bailiff came and was going to put her hands behind her back. The judge. So, listen to the judge. Listen to the judge. Right, the judge, or attorneys can complain, but the judges can do a lot more to you.
Well, the same thing happened with me in an arbitration, where the panel did look at me one time and say, "Keep writing." It's like, just keep writing. Let's just get this, I thought, get it over with and get out of here.
So you kept writing?
Because it's mostly a no write, it's a 2.5 hour minimum, I'm getting paid in attendance anyway.
Right. So another time when he was just hired to do the plaintiff, the arbitrators looked at him and he just kept writing anyways.
I think a lot of that comes with the experience as a reporter.
Choose your battle. Like when you're
Choose your
raising
battles.
your kids, you choose your battles. It's when you're court reporting, choose your battles. I guess too bad to put it that way.
I mean, we really deep down, if you got experience, we know what's wrong. We know what we're not supposed to do.
We know we're not supposed to do,
We
but
know
if we're
what's
getting
unethical.
paid,
We know
and-
what's unethical.
Right.
We do.
Okay. Anything else to add on that? Okay. So we're moving on to number 12, right? And I think we've talked, no. When in court, if the judge tells you to strike an answer, you should A, strike it, or B, leave it in case there's an appeal. B.
Leave
Right.
it in case.
Leave it in case there's an appeal. Right.
Do you mean in the transcript, but like if you read it back, are you supposed to read, like say the judge says strike it, and then later somebody says, could you read it back? You don't read it?
I think that's different, like if the judge says strike this from the jury's ears, you know what I mean? I think if you're reading back in that case, you would not read it back because the judge ordered you to, strike it from the jury, but it's left in the case just in case there's an appeal later, it goes to a higher court.
It's up to them to redact it, right?
Yeah.
Right.
So. Okay, I believe we talked about this one before, but who would like to read number 13? I think we had some mixed emotions on this one. Okay, thank you.
On the caption, if the defendant's name is spelled wrong, you should A, leave it as is.
Okay. On the caption, if the defendant's name is spelled wrong, you should A, leave it as it is. And we've already talked about that, so. Okay, number 14. If a portion of a transcript is confidential, you should B, put in a separate transcript and mark confidential, right? Yes, okay. Number 15. Yes, ma'am.
When a deposition is written and signature is reserved, but the attorney that reserves signature on behalf of his or her client doesn't order, you should A, set up a time and a place for them to review the transcript.
That's correct. When a deposition is written and signature is reserved, but the attorneys that reserve signature on behalf of the client doesn't order, you should set up a time and a place for them to review the transcript. Just because there are attorneys that cheapo and doesn't want to get it, they have the right to read what they said and correct anything. And if it's a good job, I might, out of kindness, if I'm happy I'm getting a big paycheck, if like it was an 0-4, maybe send them a complimentary or
Never.
transcript. Never? You guys never do that?
Not for free.
Never free. Okay. A doctor who's not a party, right. No. Okay. Out of professional courtesy, if they're not a party, if it's a doctor's debt, give the doctor a copy. Huh? You hate through it? Yeah. You're supposed to. Yes, ma'am.
But in general, if they're not a party, they're generally represented by counsel, and the signature letter goes to dear Dr. So-and-so, your transcript, please review the copy of your transcript. You're giving it to them as a courtesy, but the address, it's still addressed to their attorney, who's appearing there for the doctor. They're not a party, he's just representing the doctor in the deposition.
I'm not following this. I'm not following that. If it's an evidence step,
Oh, not in evidence, the discovery, obviously.
It's an evidence step, they can't
it's an evidence step they can't
no.
reserve. But you're saying on a discovery step that the attorney's being represented? The doctor?
A copy of the transcript is given as a courtesy to them for review.
Yes.
Yes. Okay, that's what,
But the letter goes in the name of the attorney.
of the attorney
Because you can't have correspondence going directly to the doctor.
Okay. So she's saying that the copy still goes to the attorney because you can't have contact directly with the doctor. So
They're not giving a free transfer to the attorney.
But wait a minute, are you talking about the attorney for the doctor?
Yes.
Yes, so he's not a party.
Right.
He has nothing to do with it other than just representing the doctor.
Right.
So you're sending him like a mini or a complimentary.
right. You're sending a mini or yes,
So
exactly.
it's a little different than sending
A free copy.
a free copy to a
Right.
party.
Yeah.
Production device takes care of that.
Okay. Number 16. Who would like to read number 16? How about you, sir? Yeah.
If you are in court and they are playing a videotaped evidence deposition, you should B, ask the attorneys if you need to include that, and if not, put in a parenthetical that says whereupon further proceedings were had that were not stenographically recorded.
That's what I have is B, put in the parenthetical. You ask the attorneys if they want it taken down, and if they say no, then you put that. But I hear, ask the judge.
No.
I know, on appeal, they cannot appeal if you didn't write it.
Oh, well, that's a new rule. She says they cannot appeal if you did not write the,
That part of it has to, you have to write it anyway.
No.
No, because they have the transcript. from
They
the
have-
evidence stuff.
The transcript is part of the
They
record.
have the transcript.
they have the transcript. She's saying no because it has to be written because it can't be appealed, and everyone is saying no because it's in the record. The evidence, if they play the evidence deposition in court, and if something comes up during that, you start writing. If someone says something, you start writing right away to protect the record. But
Yeah.
yeah. Oh, well, I always stayed in the courtroom because they might be like, oh, that if you have somebody in there reading an evidence reading, they're not playing it a videotape. That's okay. That's
That's different. That has to be taken down.
Right.
No, we're only talking about
the video.
video.
Because the doctor can't appear.
The doctor, yes, the doctor. What were you gonna say?
We don't always take it down if it's being read. It depends on what our client wants us to do.
It depends on what the client wants you to do, right?
Even the judge will say, what does your client want you to do? You have to take it.
I don't know.
That's the first time I've ever heard that, what you said. So I'm gonna check into that to make sure.
Yeah.
How do you even hear the video? I mean, to get it down?
It would be very hard to hear a video to get down.
When they're playing the video in court, yeah, you can get the gist, but we can't get every word out of it. You can't hear it perfectly.
They get the transcript, a copy of the copy.
Right. So I prefer not to write it.
Call the reporter, tell her to send you a file on it. They took it.
No.
Okay.
Question.
Yes, ma'am.
Wouldn't you add something that the videotaped evidence deposition of Dr. So-and-so was...
You would. She asked if you would add at this time a squib. At this time, the evidence deposition of Dr.
So-and-so was
Freeberg was played and not
in open court.
In open court. Yeah, you could add that. Once it gets stylistic, whatever blurbs you use, you know. Okay. Okay, number 17. Would anybody like to read that one?
If a witness
witness is not answering verbally, it is the court reporter's job to ask the witness, was that a yes or a no? And I said no.
Right.
No? Okay.
It's not that.
I've done it out of frustration.
You've done it
After
out.
a few times, and the attorney's not saying anything, it's like, is that a yes or a no?
And generally, the attorneys appreciate that.
Right.
Oh, thank you, that's my job, thank you.
You know what I do? I say, I'm sorry.
Yeah.
That's like, it's like, did you say something and I didn't hear it? That's how I.
Oh, yeah, you could just say, I didn't hear you. I didn't hear you, I'm sorry.
Okay, this is good. She, in the back, she just says, I'm sorry, like, did you start to say something? Did you not start to say something?
Or they say, mm-hmm.
Mm-hmm.
I will put, mm-hmm.
I will put mm-hmm
And
too.
sometimes I just repeat that back to the witness, mm-hmm. Oh, yes, I'm sorry, I'm sorry.
You know, I always get a kick out of when the attorneys give the preamble to the witness, they say yes or no, because the court reporter can't spell or
Yeah,
and I'm
can't
thinking in the
say
back of
those
my mind, oh, yes, I can. I don't want to do it, yeah.
I can't spell it, why are you saying it now?
Yes.
With that whole yes or no thing, if the witness isn't verbally saying anything, I don't say anything because I don't know if that's a tactic on the other side is happy because their witness isn't going to have
Right.
anything on the record. It's between, I believe it's the attorney that needs to say.
The attorney needs to speak up.
They do, but
Because I mean, that could be a tactic on the other side. Well, hey, I'm not saying anything.
It depends on the attorney, because I was yelled at one time by one specific attorney, and I told my boss, you know, what happened, because it's the same thing.
You were yelled at for what?
For saying yes, you know, or mm-hmm, or, you know, to get a response. That was his intention. To have him just, mm-hmm.
But he's
and-
putting the onus on us.
Right, no, I yelled
Which
at
is-
him, you know.
So we usually, we shouldn't say anything unless it is very frustrating.
I'd say
Or
something
if they're
every time.
whispering and you can't hear them and the attorney doesn't ask them to speak up, then I would say, what was that? Or because, what are we gonna put down? They're obviously saying something, so we need to figure out what they're saying. But if they're saying something, if they don't say anything, then no.
Can I say something to that?
Yes, sir.
Over the years, I've been an official for a few years. I've had people, we were always taught that, well, your notes are going to say it all. Your notes are the record. I've had people, attorneys and whatever, well, that's what the court reporter wrote, it doesn't mean anything.
Now, wait a second, let me
Yeah,
get this, let me repeat this. You've been an
Yeah.
official for years, and you've always been told, well, the record will speak for
Well, you know
itself.
what? Forget about
and-
being an official,
Okay.
being a court reporter.
Being a court reporter in general, okay.
People, it's happened to me, it's happened to reporters I know, their notes have gotten challenged. I've taken, maybe this was not the best step, but I've always told myself, this isn't gonna happen to me again. I'm gonna have a recording of everything. When I'm sitting there and somebody's saying, mm-hmm, 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 it's like, no, I want a yes or no on the audio. Because it's just, you know, Murphy's Law. Sooner or later, somebody's gonna come after you and say, well, I can just see it happening.
Okay, so
He or
in
she's,
this
you
case,
know, I'm just trying to protect
he's
myself.
trying to protect himself. If the record is ever challenged, he wants it on there verbally. Is that a yes or a no? Because it's not the writer just not giving a darn and just writing what, I see what you're saying,
Yeah,
protect
because
yourself.
I can see the scenario where somebody would actually, I can see it, where somebody would look at me and say, well, you're saying she said, but it really sounds like mm-mm to me. I don't want to get into all of that.
Exactly, exactly.
So when the attorneys,
So in that,
when they just keep letting them go on and on, that's, you gotta speak up.
you have, okay, yes, ma'am.
That's why my judge told me we all need, as court reporters, to have an audio backup. So we're not challenged ourselves. We have a backup exactly for his purpose, just what he's done.
Okay, her judge told her, and what a nice judge, to look out for you, that to always have an audio backup in case you're ever challenged on something.
So far, it's
I mean, because there's the Court Reporter Act that says we're allowed to use electronic recording devices.
Mm-hmm.
Take advantage of it.
Because there's an act that we're allowed to use audio recordings. Yes, ma'am.
I've had attorneys at times where they would say, you know, the court needs a verbal response. They say, mm-hmm. And then I've had at times where they'll look at me like, how come you're not interrupting and asking if it's a yes or no? So I get that a lot, where I feel.
Okay.
I think it's attorney dependent.
Yeah.
Yeah,
On how you.
sometimes the attorney will say, is that a yes or a no? But sometimes they look at you And that's why I'm saying follow their cue. If you've worked with that attorney before and they're not going to get mad at you, I think that in that instance it's okay. Was that a yes or a no? If it's repeatedly happening, you know, and if you don't get daggers at you from the other attorney, I think it's okay. Let's do that. Did anybody else have their question raised? Hand raised?
Well, it's like Anita mentioned earlier, who cares if the attorney gets mad at me? So what?
That's all right. So what if the attorney gets
Can you stand up when you say that?
I'm very professional about it. I've learned over the years, you know,
Especially when attorneys are pushing phones in your face.
You know what? We're supposed to provide a service, a professional service, and over the years, I've just found it was like, so what? You're mad at me, big deal. I'll never work with you again. So, but I'm not rude.
Right.
But I'm not putting my license on the line for anybody that, you know, they might get mad at me.
Right. We're not going to put our license on the line just so someone doesn't get mad at us. Okay, let's finish number 18 of this section. When an attorney, are you guys ready? When an attorney is reading and says quote, unquote, do you put the words quote, unquote in and the quotation marks? For example, which would be the best way to show she said you were fired? A, she said, comma, quote, slash, unquote, comma, and then the quotation marks, you were fired? Or B, she said you were fired? You said, you said B? I like B. I like B. You say neither. Why?
I got yelled at once from a judge. I was interpreting, you know, I was told I was interpreting where the end quote goes.
Oh, he said he was interpreting.
I just put, she went to the word typed out, quote, to the store, period, typed out, end quote.
That's what
exactly what came out of their mouth.
Right, because a
Yeah,
lot of
that's
times they
really
don't
it.
tell you where the end quote is.
Okay, they tell you where. I've just started recently. People will be reading from acts or statutes, and they're like, I'm reading this or I'm quoting this. Then I look at the quote, or if he says I'm quoting, I'll put I'm quoting. Then I'll put the colons, paragraph, and then start with the quotation marks. If they say, I don't know, it's.
I don't have it on paper, I can't see it, I don't know if that's a
Somebody
direct.
said once that unless you have the document.
Unless you have the document in front of you,
And then they misread it, they missed a couple of words.
if you can't see if they're doing it verbatim, then you don't quote that at all.
I'll put the word. that
You'll
they
put
said
quote
and
and unquote, but you don't put
But not the quotation.
Okay. And they do read it wrong.
They're reading a quote and it's all, it's completely wrong.
It is wrong. And then you have your dashes, starting quotes.
I'm like a monkey sitting there looking and writing and.
Right. That's when you put the, in parentheses, as read.
As read. Yeah, I've been noticing that's coming up a lot. I like that as read. If they're not quoting it correctly, you can put as read in there. Okay, you guys did a very good job on that first section. We're going to do one little exercise and we're going to take a break, okay? At this point, I would like you to pick a partner and discuss your most embarrassing moment at a proceeding where you were sent to report a job. The most embarrassing thing that ever happened to you. And I know there's been some good examples already, like he had the phone shoved in his face. Something embarrassing that happened to you at a job. We're going to pick a partner, and you guys are going to talk about your most... Ladies and gentlemen, are you guys hearing me on this side of the room? Okay, we're going to get a partner, and we're going to talk about the most embarrassing thing that we've had happen to us while we were on a job. And then we can share a few. Take about five or so minutes and discuss that.
Look at all that money. They're all, I know.
Okay, you can think of something. Yeah, it's like always when you're at a party, oh, you must hear the interesting things, the most interesting things. Right. Okay, so have some people had a chance to talk about the most embarrassing, and we'll start what you can think? Who would like to begin and share them? Okay.
She's volunteering. I was going to a hospital to take the doctor's step with out-of-towners, and when we were all in the conference room, and I started to unpack, and I forgot my machine.
That's not embarrassing, that's a nightmare. She was going to a doctor's step with a bunch of out-of-town attorneys, and when she got there, she realized she forgot to pack her machine.
What happened?
What happened?
Well, I did have a tape recorder, so I put that on the table. I had called my office, and someone in my office did it over the phone.
Smart. So
I didn't charge.
Okay. She didn't charge. She called her office, and somebody did it over the phone.
That was smart.
Okay.
Worse than
Yes. First time I've ever heard it actually happen. Oh, not to laugh, but it's over.
Now I laugh.
Yeah. Okay, anybody else like to share an embarrassing situation?
I had something similar to that.
Okay.
I went to a job and I forgot my adapter, and my writer wasn't charged. So I couldn't do anything. I had a tape recorder, and they agreed to let me do the tape recorder.
Can't you also turn it on manually and then retype your notes in later?
Yeah, no, I don't know.
Certain machines, I don't think do.
There's a way, but you don't really.
There is.
Yeah, but where it's recording.
No, it's not recording. It's just, it's a
There's no
manual.
paper. If you have no paper, what's the point?
Okay, any more embarrassing stories? Yes, ma'am.
Still have paper.
I was a new reporter,
The
and I was working in Judge Riley's courtroom. I don't know if anybody knows C. Riley.
The
And,
tall redhead?
no. And he was very strict.
I know who you're
Started at
talking.
9, break in the morning, lunch for an hour, break in the afternoon, we went till 5. That was it. And he always started off saying, Mr. Reporter, if you think I'm going to go out, I'm telling a joke, you stay on the record, you don't go off the record till I tell you to go off the record, blah, blah, blah. So then he would never do his sidebars outside of the courtroom. So there was a sidebar, The two attorneys went up behind the bench to his chair on the one side, and there wasn't any room for me. So I grabbed my machine, I went around the other side, I dropped it down as low as it could go, and I got on my knees and I said, I'm ready, Your Honor. And he said, Mr. Porter, get off your knees. I'm ready, Your Honor. And he said, no, you gotta get off your knees. And I said, I don't understand, I can't write, I don't understand. He called a recess, went to the other empty courtroom and laughed his ass. The attorneys were laughing, and all of a sudden I got it. I've been on the bench for 15 years, and I've never had a court reporter on her knees behind my bench. It's not going to start today.
What a dedicated court reporter.
Yeah.
Okay.
Oh, God.
So this judge that she worked for, I wanted her on the record all the time, even at sidebars and stuff, even if he was on a joke, and he never left the courtroom for sidebars. So she got down on her knees to write, and he's like, Mr. Porter, get off your knees. And then he left the room and was cracking up. He's like, I never had an attorney on her knees. That's pretty embarrassing.
Can I say something?
Yes.
Is that the African-American?
Yes, yeah.
He's
He ended up becoming a chief judge in Margot.
Yeah.
But I had another one with him too. He thought I was hysterical.
He has-
We were
he
in
has-
chambers doing motions and lemonade, and I'd been there all day, and it was 11 o'clock at night, and I was exhausted.
Oh my God.
And so I'm sitting on the edge of the chair and I'm writing, and my back is killing me. So then I go to lean back, but nobody told me the chair was broken. And so I went all the way over. My feet came up, hit my machine, my notes went flying. He started laughing and then stopped and goes, oh my God, are you hurt? Are you hurt? And he helps me up and they're fixing my notes. Are you okay? And I said, nothing, Bruce, but my pride. And he goes, God, you make me laugh.
The same lady flew out backwards from her chair. Her notes went flying.
Can I say something to that?
Yes.
He has an identical twin brother.
Does he really?
Who works at 69 West Washington, across the street from City Hall in downtown Chicago. And I thought I ran into his brother, but it was him. And because I know his brother too, and he knows I'm a court reporter, and he goes, but it was the judge, but I didn't realize. And he just looked at me and goes, how you doing? I go, I'm fine. I go, I was with your brother last week. And he just let me go on. He let me go on and go on and go on. And all of a sudden he looked at me and goes, well, what'd you think about that hearing, Mr. Reporter? And I just like, I mean, thank God I didn't say anything bad about the judge, because I would have been saying it to his face. And
Right. Okay, any more embarrassing stories anyone would like to share? Yes.
Embarrassing, kind of offensive.
Okay.
I was at a deposition. We had been there all day. It was really grueling. They were fighting. It was really fast. And it was like 6 o'clock at night. And I had been there for like 9 hours. I was running out of paper. I was exhausted. I needed to eat. I don't know if they had people from out of town. I can't even remember. It was so long ago. But they just wanted to keep going. And I was spent. And I was like, because they were kind of going, oh, well, should we keep going or not or whatever. I'm like, I'm done. I can't write anymore. And the attorney said to me, he looks at me and goes, you know, you should really go and, you know, start working out at the gym so you can go all night. And he like didn't even get what he was saying. I just let it go.
Okay. Any more stories, or should we take a quick break?
Yeah.
Yeah, quick break? Okay. Let's take a 15-minute break. Okay, I hope we all had a nice, refreshing break. Before we move on to section 2, this gentleman somebody wanted to share another story, so we're going to do that before we move on.
Who do you call a gentleman? My first cart job was in 1992. I had never ever thought I was going to be riding cart. It was at the NCRA convention in Chicago. It was going to be the awards banquet on Saturday night. Sitting at a table writing for the president of all the late deafened adults, and he was obviously hard of hearing. The prior 2 days, I had been on a landfill siting hearing, and we'd gone from 9 in the morning till 10 at night, 2 days in a row. almost 1,000 pages. My arms were like steaming stumps, that's how I felt. And so I'm supposed to cart for this guy. The opening remarks and everything were really okay. And then, I don't know if any of you guys know Herb Starkman and Lou Ranello. They are up there at the podium, and they go into this comedy shtick about the diesel fitter. It's about stockings, a woman's stockings, and she had a speech impediment, and it meant really was supposed to be like, these will fit her, but they're talking diesel fitter. And this poor hard of hearing man sitting over there like, WTF, the whole thing. At the end of that, I just wrote parenthetical that said sorry.
Okay, moving on to section 2 now. How punctuation and capitalization can make sentences read differently. And before we started, I noticed that there are misspellings here in the header, big time. And I think what it is I had my daughter helping me with the spacing, and I didn't go through and proofread. So I think that's what that is about. I know, shame on me for not double checking my AP student.
Where's your license?
I know.
Hand it over.
But punctuation, if used properly, can greatly enhance the overall structure, organization, and clarity of our writing. But if it is used incorrectly, it can become cumbersome and inhibit the reader's ability to understand the material flow. So these sentences are just fun. They're fun sentences to show how grammar and punctuation can make things read differently, and there's different interpretations of these. So just take about 10 minutes and go through, and we'll see what some of us have. Is everybody pretty much finished with this section? Okay. Rosemary, would you like to do number 1?
Let's eat, grandpa. Capitalized grandpa.
That's right. Number 1, let's eat, capitalized grandpa. Because you don't want to eat grandpa.
I'm hungry. I can eat
You're
grandpa.
hungry.
Why would you capitalize grandpa?
Because you would capitalize grandpa because you're using it as a pronoun, like in place of his name. You're addressing him. Let's eat grandpa.
So if you said let's eat uncle, you would capitalize uncle?
Or even mother. No.
If you can replace it with the word Bob, yes.
That's a good trick. If you can replace it with the word Bob, yes.
That leads to another question.
That leads to another question.
So in a transcript, when counsel are addressing each other, well, counsel, or, the judge says, sir, counsel.
In a transcript, if it's
In
counsel
the middle of a sentence.
addressing each other,
In the middle of a sentence.
in the middle of a sentence, sometimes I do, sometimes I don't. I mean, it depends.
What's the question?
The question is, would you like
To capitalize sir or counsel.
to capitalize sir, counsel in the middle if they're addressing each other? Everybody's saying no. She says she does. And,
I do on council, I don't start.
you don't, yeah, not on sir. Not sir or ma'am, but counsel, doctor, sometimes they're referring
Doctor, I
to.
don't.
Doctor, you don't?
Doctor.
Doctor, you don't.
That's usually at the start of the sentence.
In the middle, too.
Can you qualify that answer, doctor? Could be at the end. And I think it's just, I like that though, if you can substitute Bob in there, cap it. That's a good way to remember it.
Ma'am.
Okay, Dan is gonna read number 2.
I propose 2 answers for you.
Okay, then let's hear your 2 answers.
It's not what you think it is.
Thank God.
The first one is just capitalize Uncle and capitalize Jack. John helped his Uncle Jack off a horse.
Right.
Okay. Could it also be if he's got more than one uncle?
Then you would put the,
You would do Uncle lowercase, comma, capitalize Jack, comma.
off a horse.
Yeah, because he could have an uncle named Bob.
Right.
No.
Doesn't matter that that's the only uncle.
So you capitalize uncle and Jack.
What?
You capitalize uncle and Jack.
Capitalize Uncle and Jack, yes.
Initially, yeah, that's my first.
That was his first, but he's saying if there's more than one uncle, you could set off Jack in commas. If you wanted to get deep into it, but. Okay.
Maybe John is thinking, who knows?
Okay, number 3. I'm looking for this lady right here whose daughter likes to bake apple pies. Can you read the Rachel Ray question?
Rachel Ray finds inspiration in cooking her family and her dog.
And how would you punctuate that? Did you say where the commas would go?
No. First of all, I think it should be for her family. Yeah.
Cooking. She's not cooking for her family. She finds inspiration in cooking, comma, her family, comma, and her dog. And this brings up the point of the serial comma or the Oxford comma, and I don't know who's still doing that. When you take out the comma before the and, who does that?
So you don't have a comma or and? Yeah.
No comma.
You take it off before the and?
Yep.
No, we learned that.
When my son was in school, I learned, I learned it from his teacher that there's a comma before and.
There's a
in
comma
series.
before and in a series.
Now I learned it differently, but.
See, people are getting away from it, but then they're coming back to it again for legal purposes because it could mean something else. So I started putting the comma back in before the and.
Like there's an example.
There's an example?
In the caption, like there's a bunch of defendants, and you don't put the comma before the and after the last defendant. They can nitpick and say that you're suing those two together or something like that instead of
as one
John
entity?
and, something like that. So it should be before the and.
I just wanted to bring that up and see how you guys felt about that. But sometimes that comma before the and can make a difference. So, okay. Now this one is a little confusing, number 4. It could be interpreted a few different ways. So who would like to take a shot at that one?
Number 4?
Yes.
I put, who did the inventory search, comma, other than booking officer, comma?
Question mark, right. Yeah, and I would capitalize the B for booking to make that his title. He's the booking officer.
No, doesn't booking mean?
Well, yeah, if you leave it like it is, it looks like Officer Compton's getting booked.
Exactly.
Getting arrested.
If you don't cap it, it looks like maybe he's getting arrested. Yeah.
I'm looking at it like they're asking a question.
Who did the inventory search, comma, other than booking officer Compton?
Other than booking, comma.
Yeah,
Officer
comma.
Compton.
Yeah, that's what I have.
Asking him a question.
But is booking an inventory search?
Yeah, because it doesn't make, if you don't capitalize it, it actually, you could say that maybe he's being arrested, but even so, it's not going to make any sense.
Right.
What does booking have anything to do with an inventory search?
Who did the inventory search, comma, other than booking officer Compton? Booking officer Compton did the inventory search.
If you're using booking as his title.
Right, and that's why you would capitalize that.
But if you don't use it as his title, the sentence makes no sense.
If you don't use it as title, this doesn't make sense, correct? Okay, who would like to do number 5? You guys are so quiet over here. Can someone over here do number 5? You have a lovely smile.
Okay, number 5, hunters please use caution when hunting pedestrians, comma, using walk trails.
Hunters, please use caution when hunting. I would put a period there or a semicolon, Pedestrians using walking trails.
Hunters, comma, please use caution. Hunters,
Yes,
comma.
right. Hunters, comma, please use caution when hunting. Semicolon, pedestrians using walk trails. Okay? Wait a minute. Sam doesn't like that.
It's addressing hunters.
Walking trails, that's just kind of hanging.
I think it's a sign.
Yeah.
It's not like a.
Right.
Put it in like that.
No. Hunters
are using
Walk trails.
don't shoot the pedestrians.
Yeah.
Why not just leave hunters? Please use caution when hunting.
You're
Because
hunting
they're not hunting the
pedestrians.
pedestrians. That's why you need something there.
Why they need to use caution, pedestrians.
Yeah,
Right.
Don't shoot, there's people
Don't
walking.
shoot, there's people walking.
There are people walking.
There are people. Right. We good with that one, Sam?
Yeah, I guess.
Okay. Okay. Can you read number 6?
So you're not just saying hi?
Oh, I'm saying hi, but.
Do not use Kamatani.
Okay, that one, if you leave it with no punctuation, it could be like, don't use Connie, she's a bad court reporter or a bad babysitter. And now, just putting the comma in front of Connie, don't use drugs, Connie, or don't, so but you do need, that could have 2 different meanings. Okay, number 7.
All fields are closed. No trespassing, period. Capital violators will be prosecuted.
Right. Did everybody get that? All fields are closed, no trespassing, comma, or, I'm sorry, period, capital V, violators will be prosecuted. Here's an easy one, number 8. Who would like an easy one? Okay.
Jim needs a camera battery and case. No punctuation. Right.
It's a camera, comma.
Those need commas.
It could be both.
It could need a camera.
Depends on your interpretation.
It could need a, okay. That could go either way. They're open to interpretation.
Yeah.
If in that case, you would be needing a camera, battery, and a case. But if you put the commas, he needs a camera, comma, battery, comma, and a case.
Right.
I mean, you could say that.
Which is why you should write your punctuation on the job.
Write your punctuation on the job. I like that. And he said that's why you should write your punctuation on the job, which we all do. So, yes, good point.
Yeah, if you can. 'Cause you're getting-
Okay, who would like to read number 9?
I'll read it.
Okay, thanks.
Jane claimed John made the mess, and I didn't do anything.
I didn't either.
I didn't either.
Okay, I did.
Jane, comma, claimed John, comma.
And you know what I did? I put Jane in quotation marks, comma, Jane claimed John, quotations made the mess. John was claiming that Jane made the mess.
But would it be wrong if Jane was claiming John made the
How about
mess?
Jane?
Claimed John, right.
Like Jane said.
What if John really made the mess?
Jane claimed, comma.
Jane claimed comma.
Like I said, these are open for interpretation, just an exercise in showing how different punctuation can make different things read. She said that's why audio is important.
Oh, you mean we agree?
But that means Jane made the mess. No, John is saying Jane made the mess. Jane is saying John made the mess.
It could go, that one could go both ways. You're right. Okay,
You can take that.
number 10. Yes, ma'am.
Sure.
Right.
Is she rather tall, or is she beautiful and tall?
See, we don't know. So if she was 6 foot tall, she would be a pretty tall girl. But I think that she's pretty and she's tall, so I put a comma in there. Interpretation. Okay, Sebastian, number 11, is my son, and he's nuts. But thank God he doesn't do the umpire act and actually, show us. So would somebody like to read that? Or correct it anyways? Well, I'll go ahead. Sebastian, comma, can you calm down, comma, please? You're always showing us your, that needs an apostrophe.
Like you are.
Yeah, you are, you're always showing us you are nuts. Okay. How about 12?
I didn't do anything.
You didn't do anything? I didn't do anything either. Because if you put a comma before, don't use commas, and then you put a comma which are unnecessary, you're saying they're unnecessary, which we know we need commas, so nothing there.
No, I put it down.
Number 13?
After commas.
Slow period. Children crossing.
Very good. Very good.
Or it could be commas.
Semicolon, or slow period, children crossing. Okay, how about number 14? Conversation down there, ladies? Or just anything you want to share?
I was just asking them what they do as far as punctuation with, like, this is standard to a doctor, like, doctor, can you please tell us to a reasonable degree of orthopedic certainty, does this patient need further treatment? What do they?
Okay, she has a punctuation question, comma, or doctor, can you tell us within a reasonable degree of medical and surgical certainty? And you want to know if you would put commas to a reasonable degree? I don't. I wait until after they get that whole question out and then I comma. I don't set it off.
I set it off.
Just a second comma. Does anybody else do it differently? You set it both off?
If you're going to, you have to have them in front of the two or an after because it's a parenthetical phrase. So you can't just like.
She's saying it's a parenthetical phrase. I'm not looking at it as a parenthetical phrase in that sense because
They want it to his, they want it to that degree.
No, I'm just saying if you're going to use them, you should probably surround both or leave it out completely. I wouldn't use. I wouldn't use. I personally wouldn't use it at all. But if you're going to, it should probably be front to both sides. That's what I think.
Right. Can't see that.
see, I wouldn't set it off to a reasonable degree of medical certainty. Doctor, can you tell us whether the patient was disabled? They want to know to a reasonable degree of medical certainty whether the patient, but then I'm thinking that you wouldn't need that one there. You wouldn't need that one. I think it depends on the sentence, like if it's an introductory clause or something, then you would. So it's the way that it's phrased, but I do not set that off because to a reasonable degree of medical certainty.
Right.
It's the issue that is the, yeah, right. It's the issue important to the question. Okay, number 14. You guys need some more chocolate. Yes, ma'am.
Is the signature comma at the bottom comma of your mother, question mark?
Very good. Is the signature comma at the bottom comma of your mother? Question mark. You don't get that one?
I don't get that.
It's not phrased really well. It, like, is the signature at the bottom of the document of that of your mother?
I did of, comma, capitalize your, question, and then question mark at the end. Because is the signature at the bottom of the words your mother?
Oh, yeah, I just quoted your mother.
So like, I don't use quotes, but I set it up like a quote.
Say what you said again.
Is the signature at the bottom of, comma, capitalize your mother, question mark?
I wouldn't capitalize the your.
Oh,
She was thinking like it's like a title.
So it's the sentence, your mother stands for
Actually says your,
that it actually says.
Where the mother side of mother.
Your way makes more sense.
it says your mother on the page, so her signature under the words that say your mother.
Right. Yeah, but it's still all.
I don't get it. I don't like number 17. Woman with that.
Well,
Right.
I would just put the commas at, between at, and then end it at the bottom. Is the signature of your mother, not at the bottom. That's how I would do it. Okay, who would like to read number 5? I'm sorry, Val, if that confuses you, but I'm sure you're way. Yeah, it's kind of confusing. Yeah. Okay, number 15.
Is that brats or brats?
Well, if you cap it, it's brats.
I mean, brats you eat like hot dogs.
Right.
Are they talking about that or little
They're not
brats?
selling their little boys.
Yeah, little
So, Cub Scouts, apostrophe, brats for sale. And you could even put Cub Scouts, apostrophe, and then a colon, brats for sale, and capitalize the B. Otherwise, they're selling off their brats.
I think like a direct, like I'm talking to Cub Scouts, comma, brats for sale. Like, come over here and buy my hot dogs.
Yeah, yeah. You could do that as well. You could put the comma, like you're talking, Cub Scouts, comma, brats.
But
So.
I didn't do an apostrophe, just Cub Scouts, like an announcement.
Okay.
Colon, brats for sale.
Then that's fine. That's fine. Open for interpretation, like you said. Okay.
No, I don't think so.
16. Very good. And you're looking at me? Do you have a question?
Well, this is like, this judge over here is correct.
That's why we're putting, that's why,
Yeah. This one judge.
That's true.
You
Yeah.
can say it without anything too.
yeah, you could, because
That's true. It's capped, yeah.
it's capped, so it's meaning like this one, referring to maybe an exhibit or a document or is corrupt.
But I wouldn't take it.
But if you're saying that judge is corrupt, they would need no punctuation and judge would be lowercase. And it wouldn't be unusual in Illinois for a judge to be corrupt, huh?
That's the first thing we heard, yeah, remind you that we're in Illinois.
Yeah. Okay, and I love having men in the audience because they're usually aren't, but
I'm not reading.
I don't think, I want to know who did that sentence.
I think that should be eliminated.
do we want to,
Not nice.
or a man is nothing without them. So we'll just skip over that one to be politically correct here, okay?
Okay.
Can we be in consensus about that one?
Yes.
A man without his woman.
Right. Okay. Are we having fun yet? Good, good. Okay, let's move on to homonyms, synonyms, antonyms, and commonly confused words. And I love vocab, so I threw this in. I really like vocab words, so just something to do and test our knowledge.
Thank you.
So why don't we take, I don't know how many questions there are.
I don't know.
Antonym means opposite of. Take about 10 minutes, 15, whatever you
I feel
need.
like you know words, and then we get synonyms.
No. A woman dash.
Oh, they're still on.
A woman dash without her dash man is nothing.
Yes.
Okay, I fixed it all.
Excellent.
A woman dash
Yep.
A woman dash.
without her dash man is nothing.
I'm worried about that second dash.
That's a case.
Can you mind coming up here? I'm sorry to put you on the spot, but I would like everyone to hear your question, and I can't remember to repeat it all back. And then while we're working on this, she has a question that she would like to run by us. And I tell you what I would do right now, since it was the next day. I'm sorry you have to pay me for it. You ordered it. It's been one day. You cancel the day after. You're paying for it. And a lot of times and that makes me not want to give attorneys transcripts until you COD them.
I was saying I
You have
took
a
a
question?
5-day jury trial. I'm an official in an hour and a half north of St. Louis. I transcribed it, sent the appeal to the attorney, both attorneys and the circuit clerk. The circuit clerk had not put it on full, like, number 5 security. 2 attorneys in that time, after that period of time, called me to say, we need a copy of this testimony, and the other one said this testimony. And a day later, when I called both of them, they said, we no longer need the transcript. I found out what was going on was the circuit clerk had not put it under a 5 security, which is the maximum security. So the attorneys were printing that case, which is a high-profile murder case, right and left. Make sure your clerks know that it's being printed if it's not under a high security. And the thing is, the attorneys hadn't paid me up front. I was just calling them back to say, this is what it will cost. And that's when they said, you know, we don't need it any longer. They never told me, nor their secretaries, that what had been going on, but I found out probably 3 days later. Make sure your clerks put your transcripts on the highest security that can be. And then my other question was, what can you do with the attorneys that you email transcripts to, how they don't send it to other attorneys, and then you lose the money?
You can't. Nothing, you're out of luck.
Right.
Or how about when they say in front of you, I'll make you a copy?
Yeah.
That's right.
Uh-huh.
That's right. But I just wanted you all to be aware with your circuit clerks, make sure they put that on high security, because
Anita, you're back there shaking your head. Could you offer us any advice on that?
I can, but
But,
I will if you want me to.
okay. I mean, I just want,
Before she speaks, I
I
don't
mean,
think
I have
I'm
my
here
own
now.
ideas about all this.
We don't have to file anything.
Sure.
yes,
I was just gonna say, I took 2 deaths this week on the same case, and it is unfortunate. We do a lot of defense men now, and sometimes 2 defendants may have same insurance with the same adjuster, and you're just kind of screwed.
It's me.
You don't.
Yeah.
You don't.
And that shouldn't matter, though.
I know,
Well,
but you should.
I can deal with that.
But it
Oh, no,
doesn't.
you
Yeah,
did
you
a
shouldn't
no
have
on
to
one.
understand, but you
if
could
you're lucky.
almost understand, but when it's a bunch of different defendants,
Could be,
that
you know.
hi Anita, welcome back.
We know up front.
Thanks for joining my
Saying it in
program,
front of
because
you,
you didn't do
they're gonna
enough
send
work.
out 3 copies.
Very quickly, my thoughts are, first of all, it's a new world. And there are new policies. And you say, be careful, make sure of, or whatever. Yes, of course, transcripts can be sent where you cannot email them to somebody. You cannot print them. And Real Legal, I believe it is, has a lot of these safeguards where you can set the settings when you send something. But what is your court administration doing? What is your deposition agency owner doing? I believe it's an individual type of thing in this day and age as to what people do regarding security. But I have to tell you, my thoughts are, number one, it's a new world. It's a different world. It's like, for all through the years, you hear people say there's to be no recording. Well, come on, no audio recording. You could buy, for a very small amount of money, a 2-ounce recorder that can record 30 and 40 hours or more. And it's not that expensive. You got that, you slip it in your pocket. My husband has a hard time hearing. He could never grasp a whole seminar at one time. So he records, and then he can listen again. It's not like he's going to record and go out and steal the material and put on his own seminar. And for the last, I've been doing my seminars now since 1993. And I've always told people from day one, if you want to record me, absolutely. By the way, I don't say this, but if anybody wants to steal the Anita Paul Real-Time Mastery Seminar, steal it and go give it, because the world needs it. I'm not into the proprietary rights of all that. That's just me. And I love it. And my friend Helen from Australia came to my workshop, loved it, took my workbook, duplicated it, taught Australians how to do real time. Oh boy, do I have a great story of that.
for some of that. The money she made, I hope
She
she
did,
gets
no,
some.
absolutely not, and I'm happy, I'm 100% fine with that. It's not about the money for me, that's just how I am. But all I'm saying is, we need to look at the world we live in today. My belief is that we should be charging more per page. We should be charging a flat rate. And then you can duplicate it to your heart's content. My friend Norman runs the largest transcription agency in Africa, South Africa. Very dear friend of mine. You should see his operation. He is not cheap. He is expensive. And does he get work? He is so overwhelmed with way too much work. By the way, one of the attorneys hired him for the Oscar Pistorius trial. It was his electronic equipment privately that supplied that particular attorney with the information. But we've had a lot of conversations on this topic, and he is probably the world's most expert, knowledgeable person in creating transcripts. And he's been to some of our NCRA conventions. I went out and worked in South Africa with him for 5 weeks. I did an arbitration. And anyway, talking to him and learning from him and seeing the way the world is, we need to reinvent ourselves. The world is reinventing itself. This business about, oh, don't copy my transcript. You know, in the olden days, it was onion skin typed copies. Carbon copies. That's right. So then we went from carbon to Xerox. And you, with the Xerox world, you want to say somebody's not going to Xerox another transcript? Come on. Let's just get real. Let's blend with today's world. Let's raise our daily rate. Norman charges a flat charge a day. You want him? Here's the cost. You want video? No problem. You want daily? No problem. You want 17 copies? No problem. None of it matters. A flat daily rate. And that's what he supplies. And I think that's what we should do. Nothing else should matter.
Thank you. I think that I would still try to get paid for that excerpt of work that you did, because it took your time out, searching for it, breaking it off. I would still try to get paid on that. And as far as if I'm in a deposition or a hearing or anything, and I see attorneys that have left their phones on or their laptops, the attorney that usually hires me will go and make sure that that's not recording, because we're the official record. They shouldn't be seminars are fine to record a seminar. I would actually like that so I can play that back. But when you're on a job, you don't want someone else having a recording, because ours is the official record. So that's all. Okay, anything else before we move on to our next section? Thank you for bringing up that point, though.
I felt like I was out of luck and I didn't do anything about it because I figured, you know what, let it be, go on.
But Anita's right. We need to safeguard our stuff too. We need to, Real Legal, I think it is. Is that what it is? The program you buy? I think there's safeguards on that. So. Oh. Check with all the different companies. Okay, so let's move on to homonyms, synonyms. Who would like to do number 1? Yes.
What is the antonym for synonymous in the list of words? De-unbending.
That's correct. What is the antonym for synonymous in the list of the following words? It's de-unbending. Number 2? Winding, yes. Okay, how about number 2? Sam? You don't have it?
D-toxic.
D-toxic, that's correct. What is the antonym for the word innocuous in the list of the following words? And that would be de-toxic.
What's innocuous? I always hear, you know.
Harmless.
No adverse effect. Harmless.
Innocuous. Okay, yeah.
Okay. Number 3. Valerie?
What is the antonym for the word stentorian as used in the sentence, some public speakers favor a stentorian delivery and emphatic gestures to drive their message to their listeners? And I said hushed.
That's correct. Agree is hushed. Number 4. I'm sorry? But you got number 5 right. And number 5 could be both because.
And number 4 is carried, C-A-R-E.
Okay, he answered 2 in a row. Yay. Okay, 4. What is the prefers insertion mark? And that's B caret, spelled with an E-T. And then number 5, the young virgin was E, chase, and probably C, both. She's pure and chased around a lot. Okay, number 6. Carla has an ingenious plan to earn money this summer. Ingenious, thank you. I'm getting tired. Is B, marked by innovative skill and imagination. Okay, how about number 7? A. Prospective, correct. Future, likely to come about. Okay, how about number 8? B. B, the suspect was attempting to elude.
But not from. Shouldn't it be?
Right, elude the detectives, cross out the from. The players were A, already. Each one was ready. Okay, how about number 10? B. Mia has B, already, one word, meaning previously studied the chapter. 11. B. The jurors seemed disinterested as counsel droned on during his closing argument.
What is the difference?
Disinterested is impatient, like I have, and uninterested is not interested. I guess it could be both. Depending. Disinterested. Anything you want to say on that?
We were just differentiating that like a disinterested party has no interest, where if a juror is there, they have an interest, but they're not interested in it.
Mm-hmm.
Could be either one.
Okay. Number 12? Can
B. No,
B.
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 Torture.
Very
Very painful.
painful, unpleasant, very unpleasant.
Torture.
Mike Tyson seemed
This is 2. A. I think it's A and C.
A and C. We'll go with A and C. Complacent. He was smug about it, and he was cannibalistic when he did it.
Oh my God.
Okay, the BMW was at the end of the B, Q. 15, the intimate lovers were very B, discreet. I hope Lindsay Lohan is ready when the director gives his A, Q. Number 17, how do you propose to
Diffuse. Not
No,
diffuse.
it's A.
It's A.
Yeah, I think it's
to make it's A, to make less harmful or tense. Yeah, to make the situation less tense. So 17 is A. Okay, how about 18? Can somebody read number 18, please?
The plane was en route A from Kuala Lumpur to Beijing when it went missing.
That's correct, 18. The plane was A, en route from Kuala Lumpur to Beijing when it went missing. It's a French word. I didn't know that for a long time. Number 19? B. Okay, I want you to sing B all together because you could put in there, I want all you girls to sing together, right? So it would be 2 words. Okay, how about number 20?
B.
B. Collectively, right? All together, 1 word, Gus earns more than Jill. How about 21?
B.
Osama bin Laden was the millionaire guerrilla fighter who became the world's most notorious terrorist. B. Okay, how about, can someone read number 22, please?
Although both are named after Columbus, the U.S. capital is the District of Columbia. B.
A.
B's the country.
I'm sorry.
B's the country.
Don't say you're sorry. Nothing to be sorry about. Okay, and I saw in Anita's booklet earlier, I was flipping through, and I love it when she says, court reporters are excellent, not perfect. I need to keep that.
Yeah.
I love that. Okay, number 23, can we have someone read that? Mm-hmm. The nursing aide with an E was accused of being neglectful in her duties as it related to patient care. Number 24?
C.
Yes. 24 is B. The material closet at Fort Bragg contained just about everything except for ammunition.
What does it mean?
It's B. It is military materials and equipment. Yes. And most of the gentlemen knew that in this group.
Pronounced material.
Material. Okay. Were you in the military? Is that how you know that?
I was.
Really? Ah. Okay. Were you the one who? Oh.
Hey.
Who left the milk on the table all night? Okay, very good. You guys have been a great, attentive audience. I think instead of getting into another section here, I have 5 minutes left. So, would you like to discuss anything we went over today, or
How about worse and worst?
worst and worst? Okay.
When do you use which? That's a question. What's a hint for that?
Worse and worse.
W-O-R-S-E or W-O-R-S-T?
Worst. It's the worst thing you've ever done.
I know, but when people talk, they just...
What is the worst thing you ever have done? That would be W-O-R-S-T.
Is it the
And you're
adjective?
comparing.
Yeah, worse is a comparative, and worst is the superlative, which is the ultimate. It's the most. You have bad, worse, and worse. Just like your good, better, best.
But I think for the SC, you have to have.
Repeat
the first
that?
one.
Can I repeat that?
So
So,
you have bad,
bad,
worse,
worse, and
worse.
and worse.
Which is the last one, the T?
Yes.
Yeah, just like good, better, best.
Like good, bad, and ugly?
Did that help?
So this one's worse than that one, but that one's worse.
Right.
Yeah. Jeff simplified it there for us.
Well, you know how people, when they say it, it sounds the same.
Well, yeah, and then you have, what is it, there's no worse for wear. I think people often have problem with that expression. No worse for wear, and people will often say no worse for wear.
It's no worse for wear. SE.
But it was worse than you thought.
Yeah. Any more questions that stump anybody? Sam? Stumps you? Oh, we had to go there. Okay. Anybody have a good example for affect and effect? Isn't one is a verb and one's a noun?
How did it affect you? But it's a flat affect when it comes to psychology.
Right. It's EFFECT when it comes to psychology, like I have flat.
No, A.
Oh, it is A.
Affect.
Affect, okay.
It has a flat affect.
This one's one that always confuses me.
With an E, it's result.
Right, E is result.
E's result.
What was the effect?
And then there's the verb effect. You effect.
When something affects as a verb, it's always A.
No, it's not always A.
No.
When is EFFECT a verb? How does it?
To effect the cure.
Oh, that's
Effect
true,
to
that's
change.
true.
Yeah, or effect the change to cause something.
Otherwise, it's affect, and people often use it incorrectly, the
To
effect.
bring about a change is effect with an E.
No, how did it affect you?
A. Is A.
How did it change you?
But yeah, to affect something as a verb with an A is more like.
No, what was the effect?
But anytime it's psychology, it's A.
How about like, could you think about what was the end result, and then that would be what was the effect, the end result? No? Could you think of it like that?
Yes.
That's right, but
Yes.
it's grammar.
Cause or result.
If something affected you.
Influence is affect.
Influenced, influenced is affect. And
Cause or result is effect.
and cause or result is effect.
How did the death of your mother affect you?
It influenced me, so it would be affect.
Right. Anything with psychology is A.
Okay, we got that tough one out of the way. Another tough one? Okay, well, you know what, then I'm just wrapping up. Thank you guys for participating and being a lovely audience. Enjoy the rest of your day.
Well, there you go. You're done. How easy was that? I hope you had a great time taking this program. Now you have a few more CEUs to add to your CEU bucket there. Now remember, if you're taking one of our longer courses, please wait until you finish all the seminars before you send us your answers. And please try to, if you're going to put them in an email, copy them in one straight vertical line, separated by the different course titles. And that makes it easy for me to grade, makes it go a lot faster, and I don't make any mistakes. Well, not so much. Okay. And also, you can scan them in order and send them to me as well. Remember, we're always putting new content up here. Every year, we will have at least 4 to 10 more hours worth of CEUs that you can get here from the comfort of your home. So if you know more court reporters that would like to get their credits that way, please let them know about it. And remember, your home for CEUs online, Jeff Justice Seminars, where you can get your CEUs online anytime.